and the conditions are as follows. First, the plaintiff is ordinarily resident outside the jurisdiction. Second, the plaintiff who is not suing in a representative capacity is a nominal plaintiff suing for the benefit of another person, and there is reason to believe the plaintiff will be unable to pay the defendant's costs if ordered to do so. Thirdly, the plaintiff address is not stated or is incorrectly stated in the writ or originating summons, or the plaintiff has changed their address during the proceedings to evade the consequences of the litigation. The court will consider all circumstances of the case to determine if it is just to order the plaintiff to provide such security for costs. Having considered all the circumstances of the case, if the court finds it is fair to do so, then the court may order the plaintiff to provide a security deposit for the defendant's legal costs for the action or other proceeding as it deems appropriate. Under Rule 2A of the same stated provision, on the application of a defendant to an action or other proceedings in the court, it appears to the court that a non-party has either assigned the right to the claim to the plaintiff to either avoid liability for costs or has contributed or agreed to contribute to the plaintiff's costs in return for a share of any money or property recovered in the action or proceedings, and the non-party is someone against whom a cause order may be made. The court may, considering all the circumstances of the case, order the non-party to provide such security for the defendant's costs as it deems just. Security for costs is a matter under the discretionary powers of the court.
In the landmark case of Lindsay Parkinson and Corporation Limited against Triplan Limited, the court outlined these key factors. First, the court looked at the plaintiff's chance of success without deeply examining the case merits. Second, the court considered if the application for security for costs is oppressive, meaning that it aims to stifle a genuine claim. The court ensured this power is not used unfairly. The court also considered if the plaintiff's financial issue were caused by the defendant's failure to pay claim. The third consideration is the timing of the application. A significant delay by the defendants can weigh against claims, as the court expects prompt applications once the grounds are clear. The court also considered whether the delay is due to the defendants or the plaintiff. The case of Aikenamari and others against Emphase International and Berhad and others follow the consideration established in the landmark case. In Aikenamari, the plaintiff claimed they were induced to invest in the scheme by the defendants through fraudulent misrepresentations. The defendants likely applied for security for costs, arguing that the plaintiffs might not cover the defendant's legal costs if the claims fail. The court followed the Parkinson case, determined that the plaintiff has a reasonably strong prima facie case based on the available pleading and evidence, without an in-depth examination of the merits. This suggested that a genuine chance of success weighing against granting security for costs. Secondly, the court noted that imposing security for costs could be oppressive given the 217 foreign individual plaintiffs involved. This could inhibit access to justice and stifle genuine claim.
In order to apply for security for costs stipulated under Order 23, Rule 1 of Rule of Court 2012, there are a few guidelines that need to be followed, which is explained in this slide. The first procedure that needs to be followed by the defendant is to apply for security for costs by filing a notice of application supported by an affidavit through Form 58. One of the most important elements in the affidavit is that the defendant must show that the application falls within any of the criteria stated in Order 23, Rule 1, Subsection 1, Subsection A until Subsection D of Rule of Court 2012. It must be noted that the application must be made promptly, typically as soon as the grounds for the application are known as highlighted in the case of A. Co. against K. Limited, 1987-3 ALLER 377. The second procedure is to serve the application to the plaintiff. In the case of Structural Mass Selangor Berhad against MPPT 2001-3 MLJ 344, the court ruled that the plaintiff must be given a reasonable time, which is usually 14 days, to respond to the application. The third procedure is the service of reply. According to Order 32, Rule 13, Subsection 2, Subsection B, the plaintiff intending to reply to an affidavit intended to support of an application shall file his affidavit and serve it on the other party within 14 days from the date the sealed application and the affidavit in support of the application were served on his, whichever is later. And the plaintiff intending to reply an affidavit served on him shall file his affidavit and serve it on the other party within 14 days from the date the affidavit he intends to reply was served on him. This is governed by Order 32, Rule 13, Subsection 2, Subsection C. Next, the court will schedule a hearing where both parties can present their arguments. The court will consider factors such as merit of the case, the plaintiff's financial position, and whether the defendant has a real risk or not recovering costs. And lastly, the judgment is given by the court. It is important to understand that it is entirely within the discretion of the court whether the court deems it fulfill one of the circumstances under Order 23, Rule 1 of Rules of Court 2012 on either, first, the action or appeal may be stayed until the security for costs is provided. Second, the action or appeal may be dismissed or strike out, as stipulated in Lee Grant against McAndrew 1879 or QBD 210. Third, the court may have the authority to increase the required security even after the initial order has been made, based on the case of Badrul Azman bin P.S. Mat Zakaria against Muhammad Arif bin Kronis and 3 and others 2006, 5 AMR 749. In certain circumstances, a plaintiff may apply to the court for an extension of time to furnish the security for cause which is decided in the case of Quantum Petroleum Manufacturers Mira Berhad against Manimaran Periasami 2018, 6 MLRH 618. However, it is not inappropriate for the plaintiff to request additional time from the court to provide security for cause when the order is initially made, which is held in Mutu Raman Chetia against Lee Kong Guan 1934 MLJ 174.
Order 59 Rule 16 of Rules of Court specify the basis of assessment of cost in civil proceeding. When assessing cost, the court should ensure that the cost must be reasonable and proportionate to the matters in dispute as well as allow costs that were necessary and properly incurred. During a detailed assessment, the court considers several aspects including the amount of money involved, the significance of the case for the parties and the actions of the parties, including the precautions taken to avoid unnecessary litigation. Moreover, the behavior of the parties during the litigation process also can influence the assessment of costs. Indemnity basis in legal proceeding, indemnity basis is when a party is awarded costs, these costs can be assessed on different bases. The costs are calculated in indemnity basis. The costs are calculated in favor of the receiving party. Any questions about the reasonableness of the cost are answered in favor of the receiving party. This frequently translated into a larger percentage of expenditures being recovered by the serving party than will be the case with the standard basis.
Basically, there are few orders that most likely to be ordered by court as to cost. Firstly is Bullock order, which stands for the case of Bullock and London General Omnibus Co. This order requires plaintiff to pay the successful defendant's cost, making the plaintiff to add those costs to the cost ordered to be paid to the plaintiff by the unsuccessful defendant. The fact in this case is the plaintiff in this case two defendants, but the court only found the first defendant to be liable to the plaintiff. So the court order are as follows. Firstly is judgment for the plaintiff against first defendant with cost. Secondly, plaintiff claims against second defendant and plaintiff to pay second defendant's cost. And thirdly, first defendant to pay the plaintiff, which will also include the cost paid by the plaintiff to the second defendant. Further application of the Bullock order can be seen in the case of federal flour mills and Tato owners and others. In this case, the judge ordered the plaintiff to pay the cost on behalf of second defendants, and the first defendant must include the cost paid by plaintiff on behalf of the second defendant in paying the cost to plaintiff if the plaintiff has succeeded in action brought against the first defendant. That is a Sanderson order, which derived from the case of Sanderson and Bliss debtor. This order requires unsuccessful defendant to pay successful defendant's cost directly in the situation where action brought by the plaintiff against first defendant is successful, but action brought by the plaintiff against second defendant was unsuccessful. The Sanderson case basically is about construction of building, where the plaintiff two defendants and include defendants, architect as co-defendant. Then the only original defendant is solely liable. Hence, the court orders the original defendant to pay the cost to the co-defendant directly. It can be concluded that order of the court in respect of cost was in the following terms. Firstly, judgment for the plaintiff. Secondly, the original defendant to pay the plaintiff cost. And thirdly, the original defendant to pay the cost of the co-defendant directly for defending the action successfully.
Upon the determination of causes on the indemnity basis under Order 59, Rule 16, Sub-Rule 4 of the Rules of Court 2012, we are of the view that the Bullock order shall be applied instead of the Sanderson's order. As the sagacious ruling of the learned court, it held that causes were in the discretion of the court, and it is subject only to the requirement that the discretion must be judicially exercised, and there was no principle of law that required the county court judge to make an order for the first and second defendants to recover their causes directly from the third defendant merely because the third defendant was insolvent. Due to the fact that during the 15 months which elapsed between the delivery of particulars and the trial, the plaintiff made no inquiries as to the financial standing of the third defendant, who was in fact an undischarged bankrupt, and therefore the learned court eventually held that those risks ought more fairly to fall on the shoulders of the plaintiff rather than on the successful defendants in this case. In a nutshell, upon the notion of the Bullock order, S will be paying R for the causes as being the unsuccessful defendant. In addition, S will also be defraying the causes for which the plaintiff had to pay it for S. Therefore, effectively, S is paying for two parties, at least himself and T in this case.